For the Rebel.media, I'm Ezra Levant. I am standing outside the Royal Courts of Justice in London, where a few hours ago, the Court of Appeal, led by no one less than the Lord Chief Justice of England and Wales, granted Tommy's appeal against his contempt of court conviction in May in Leeds. It was very brief in court. The Lord Chief Justice called the place to order, and very quickly he said that conviction in Leeds was quashed, and that there were procedural problems with it, and that there will be another hearing in Leeds, but Tommy is immediately granted bail with only one condition: he has to go to that new hearing. The court then did two other things. They released a formal written judgment, and they released a 3-page summary of their judgment, which I thought was very helpful, especially since it was written in fairly plain English. I have posted a copy of that summary to my Twitter feed, and it'll also be on TommyTrial.com. I've gone through that 3-page summary line by line, and I'd like to take you through it now, because I want to let you know just how resounding Tommy's victory was, because I don't think the mainstream media, who were today out in force, I don't think they're going to give Tommy a fair shot. I already see the inherent bias against Tommy Robinson. They will grudgingly report basic facts that they can't ignore, that he's out, that he won the appeal, that the conviction was quashed. But I do not believe that the mainstream media will tell you just how detailed the absolutely scorching ruling was against Tommy's treatment. I'm going to go through it line by line, so this is going to be probably a 10-minute video, but I think you should watch it if you care about Tommy, because I believe that the ruling today shows that every single step of the way Tommy was improperly treated by the legal system. He was improperly tried. He was improperly convicted. He was improperly sentenced, and he was improperly treated while in prison. This is no longer Tommy's opinion or the opinion of his supporters like me. It is the opinion of no one less than the Lord Chief Justice of England and Wales himself. So I am now going to go through, and you can see this document on our website, but let me take you through it verbally. So this is going to be about 10 points here. I'm going to quote from this summary, which is a shorter version of the formal judgment. The court agrees that the judge should not have commenced the hearing of contempt proceedings that day. So this is the Court of Appeals saying the judge in Leeds was wrong to have rushed into a trial that very day of Tommy Robinson for contempt. There was no reason to do that. It was so shocking. Since when, in a free Western democracy, do we arrest, try, convict, and sentence someone in the course of hours? That's Banana Republic stuff. And the Court of Appeal was very strong on that. I'll read some more. No particulars of the contempt were formulated or put to the appellant. There was a muddle over the nature of the contempt being considered. That's very important. Contempt of court, well, what does that mean? It can mean different things to different people. What exactly did Tommy do that was wrong? And so incredibly, it was not actually spelled out for Tommy, so he didn't know the case that he had to meet. His lawyers couldn't meet it. And how can you plead guilty to something if you don't know what the something is? That, to me, is one of the most stunning things of the ruling today. It was such an incredible thing that happened 2 months ago, and finally we have the Court of Appeals saying that just simply is not permissible in a country where the rule of law should flow like the United Kingdom. Here's some more from the summary of the ruling today. In both the short explanation given by the judge of the general nature of the alleged contempt and the sentencing remarks, there was reference to matters that could not have been a breach. As in, the judge in Leeds referred to things that were not legally contempt of court. That it, again, I mean, you have the ruling by an Oxford-trained judge, the Lord Chief Justice himself. But let me translate this into a phrase Tommy would say. He'd say, it was a stitch-up. This ruling is a fancy way of saying it was a stitch-up. Here, let me keep going through. I'm going through the 3-page summary issued by the court today. Now remember, in court in the UK, in criminal matters, there is a written legal procedure. It's called criminal PR, or criminal procedure rules. And let me quote again from the summary today. The failure to follow Part 48 criminal PR, criminal procedure rules, was more than technical. Let me explain what that means. Sometimes in a court case, if not all the I's are dotted and T's are crossed, it's not that important. The law doesn't care about a triviality. But when you're talking about contempt of court, these are not trivialities, these are essential. And it is essential that whatever Tommy allegedly did wrong was put to him and that the rules were followed. Here the judge says the rules of criminal procedure were not followed. Again, Tommy's been saying that, well, really for years, about the way he's always been in a stitch-up. But today, to hear it from the Lord Chief Justice, this should be reverberating throughout every court in the UK. Let me continue. Here's a point I've made many times and many other lay observers have made. It's refreshing and vindicating to hear it from the Lord Chief Justice, and I quote, "There was no clarity about what the appellant was admitting or on what basis he was being sentenced." Do you understand the importance of that? It is a fact that Tommy pled guilty. He was under pressure, he was under stress. This was a drumhead trial. It was foreshortened, it was too quick. He probably thought he would get some lenience. In fact, he did get a gentle lenience from the court. They shaved a few months off it. But how can you plead guilty if you do not know to what you are pleading guilty? And maybe the judge has a different thing in his mind that he thinks you're pleading guilty to, and you have a different thing in your mind. But if there's no meeting of the minds because no one bothered to particularize his content, how on earth is that justice? What a rebuke this is from the Court of Appeal. This could be written in more florid language by any pundit, any conservative pundit over the last 2 months. But it's come from the Lord Chief Justice himself. This is a mighty ruling, and I doubt that you'll be getting this detail from the media party. Now, I want to talk about something called mitigation. Let's say you've done something wrong. Let's say you've broken the law. Let's say you're convicted and pled guilty. Let's say all that is done. That's not the end of it. There's something called mitigation, which is anything in your defense. Can you testify can you bring forward any facts? Can you, for example, show that this was not done on purpose? Can you show that you're generally of good character? Can you show anything to come to the to show a leniency, to get a mercy, or to balance out what you did wrong? That's called mitigation. And let me read to you what the court said about that. Again, I'm quoting from the three-page summary. Further difficulties arose from the limited opportunity that counsel had to investigate mitigation. There was little else which counsel could have done within the constraints under which he was working. So understand what the words there mean. Counsel, that's Tommy's public defender lawyer. Remember, Tommy didn't even have time to call up his regular lawyer. He was given a public defender who didn't know him, who was not an expert in the law of contempt. Now, and the court here rightfully does not blame that lawyer. Thankfully, there was a lawyer there at all, but that lawyer did not have time to properly get facts about Tommy's mitigation. That lawyer didn't have time to properly research the law of contempt, a very obscure area of law that most lawyers don't practice and most judges don't touch either. So the Court of Appeals says that this was not properly done by the trial judge, and he doesn't even blame the public defender. He says, what on earth could the public defender have done in a few short hours? But very scathing. I want to read some more about this. This is quoting from the three-page brief. The level of detail which could be provided to the court was very limited, and there was no opportunity to obtain character references. That's just one example of the problem when you're rushing a trial. What was the rush? What on earth was the reason to have Tommy to be thrown in prison that moment that he couldn't even be permitted to get a proper lawyer and do some proper research? Let me continue. The judges took aim at the shocking 13-month sentence. My own cursory research, obviously I'm not a UK lawyer, but my own cursory research shows that there has not been a journalist in the United Kingdom who has been imprisoned for contempt of court since the 1940s. It's just not done. And yet Tommy's thrown in prison for 13 months? Well, let me read what the Court of Appeal had to say about that. And again, you're not hearing from some right-wing blogger here. You're hearing from the Lord Chief Justice himself. The absolute top judge in England and Wales presided over this three-judge panel. And let me tell you what the three-page summary published by the court today said about that. A sense of proportion must be retained. Where a custodial term of considerable length is imposed, it should not usually occur so quickly after the conduct which is complained of. What does that mean? What do those words mean? A sense of proportion. That is, if someone does something small, he ought not to be sentenced longer than many rapists are sentenced. If something was done that requires a custodial sentence, as in imprisonment, well, let the court reflect soberly. What's the haste? If a man is to lose his liberty for 13 months, what is the haste? 13 months, you can't even wait 13 hours for a proper trial? So the Court of Appeal was very stern on this, as well they should be. As well they should be. And again, Tommy would say, stitch up. Let me tell you how the Lord Chief Justice put it in this summary of his larger verdict. A sentence of committal to immediate custody had been pronounced within 5 hours of the conduct taking place. That is not justice in the United Kingdom or any Western democracy. That is what you expect in Venezuela. That's what you expect in Iran. That's what you expect in Turkey. That is not what you expect in the land of the Magna Carta, the mother of parliaments, the place that gave us freedom for the whole Commonwealth and inspired the world. I think the Court of Appeal was downright embarrassed by that. And there were skeptics who thought, oh, this is going to be a stitch-up. They brought in the absolute top judge to make it official from the top. No. What happened is, by bringing in the absolute top judge in the UK, you brought in someone with enough moral gravitas, enough authority and reputation that he alone could rebuke the entire system with confidence and independence. There were people who said, this senior judge means the fix is in. No, the opposite happened, don't you think? Anyone who held out hope for the rule of law was vindicated. Here you have the top judge in the UK going through line by line, saying, yes, Tommy's right. Yes, Tommy's right. Yes, Tommy's right. Not because he's a political friend or foe of Tommy's, but because he loves the law. The Lord Chief Justice lived up to that ancient office. Almost 800 years old that office is. Almost as old as the Magna Carta itself, can you believe it? And I think it was well served today. I'm going to read a little bit more, and this goes to Tommy's treatment in prison. And we've talked about this before, about how contempt, being committed for contempt, is different from being convicted for a criminal offense. Lawyers say a criminal offense requires a guilty mind. Mens rea is the Latin. Now, Tommy obviously did not have a guilty mind when he was outside the court. In fact, the opposite. He was taking steps to stay in accordance with the law. He was making sure he wasn't standing on court property when videoing. He was making sure he only said accused rapists, not that they were convicted. You could see he was taking steps. There was a moment in his live stream where he looked to the side and asked a police officer, am I okay to stand here? And he received affirmation. Tommy did not have a guilty mind. He was certainly not a criminal. But listen to this from the 3-page summary of the judgment today. The order at Leeds Crown Court was also erroneously drawn up to suggest the appellant had been convicted of a criminal offense rather than having been committed for contempt of court. That is no minor mistake. That is no technicality. Tommy is not a criminal. What he did there was not criminal. It was contempt, yes, but it was not a malicious act, and he was imprisoned in a manner. Well, let me read. Don't listen to me, listen to the judge. This is a summary of the judge's findings. Again, this is a 3-page summary issued by the court. Errors like this have serious consequences upon the classification of prisoners, resulting in the deprivation of privileges and release on license, as in Tommy's brutal incarceration, his solitary confinement, the constant threats of violence he faces in prison, that all flowed from the judge's errors. Judge Jeffrey Marson up there in Leeds. I want to read one more. This is a minor point, but it just goes to how bloody many errors that judge in Leeds made. one more point. This is from the 3-page summary. In this case, it also resulted in the erroneous imposition of a victim surcharge. So Tommy was forced to pay money, and that is legally inappropriate because that only is done to people who commit a crime. What Tommy did in Leeds was not a crime. I sat through the hearing a couple of weeks ago, and I did my best to listen and type as fast as I could notes of all the arguments made by Tommy's lawyers. And I mean, maybe I'll review things more carefully, but I have not seen a single argument made by Tommy's team that was rejected. In fact, they were all accepted. The only thing that was dismissed was sort of a long shot argument that Tommy's lawyers made to appeal the conviction in Canterbury in 2017. It was a long shot. I'm glad they made it. I'm glad they turned over every stone. I don't think it ever had a chance of success. It's irrelevant anyways, because it was the conviction in Leeds that was quashed. So let's recap, and I'm sorry I went long here, but I want you to know just how brutal this ruling is as to the false and illegal ruling in Leeds. Everything about the Leeds contempt conviction was wrong. It was wrong to have a drumhead hearing that very minute. It was wrong not to let Tommy get proper legal counsel. It was wrong not to have Tommy's legal counsel have a chance to pull together the facts and the law. It was wrong that they did not spell out the particulars of what Tommy allegedly did that was contemptuous. It was wrong. It was wrong that Tommy didn't know what he was pleading guilty to. It was wrong that the sentencing from arrest to sentencing took 5 hours. It was wrong to have a 13-month conviction. Disproportionate is what this court said. It was wrong that he was sentenced as a criminal as opposed to just being committed for contempt, which is a different thing. It's a civil offense. There's no mens rea. There's no guilty mind. And it was wrong that because of these other errors, Tommy has endured 2 months as a genuine political prisoner. And I say that thoughtfully. I don't want to throw around the word political prisoner. Britain is still a great liberal democracy, but not in the case of Tommy Robinson they weren't. I told you all the flaws. And what resulted from all those flaws, what resulted from this stitch-up, was that Tommy has been in effectively solitary confinement for 2 months. For what? For a political journalism crime. Not a crime, as the judges say. For 2 months, for a political disagreement with the authorities, he's been in solitary. He's been suffering threats of violence within prison. I'll do a separate video where I articulate those. But I just wanted the purpose of this video for you to know just how much of a vindication today's ruling was for Tommy Robinson and everything he's ever said. I note that Tommy's first book, a bestseller by the way, called The Enemy of the State. And someone would read that and say, Tommy, are you sure you're not exaggerating? Are you really being treated as a political prisoner? Come on, surely that's a conspiracy theory. This is the UK. It's not Vladimir Putin's Russia. It's not Erdogan's Turkey. This is the United Kingdom. Well, you can no longer ignore Tommy's complaints about the inherent bias in the establishment, because no one less than the top judge in the entire United Kingdom has agreed on every substantive point. Tommy Robinson is not guilty of contempt, was mistreated, and has thankfully been set free. Now, the matter will, if the Attorney General wants to, be returned to Leeds for a proper hearing. And we'll cross that bridge when it comes. But everything you have read about Tommy, especially that odious ruling on May 25th, has been shredded and devastated by the Royal Courts of Justice here today. This is a great day for freedom and a great day for those who held out hope for their friend, Tommy Robinson. For the Rebel.media, I'm Ezra Levant. I'm back in London covering Tommy Robinson's appeal because I don't believe a word the mainstream media has to say about him. To support my journalism, including the cost of my airfare and hotel to get here, please go to tommytrial.com.